Good evening, everybody. I informed you several times that I have devoted 3 years of my time to study the Constitution intently and wrote 2 books, Indian Politics versus Indian Constitution in English and Bharata Prajalamagu Memu in Telugu, both of which are available online worldwide through Amazon, Flipkart, Kobo and Notion Press, etc. online platforms. People say India has the largest written constitution in the world, compiled by none other than Dr. Ambedkar, who was himself a barrister of law and a doyen of law and an economist. We also boast of being the largest democracy in the world. Despite all these attributes, I was surprised how there is so much of political instability, political uncertainty, political immorality, social strife and poverty in India for the last 75 years. Having written these 2 books, I have distributed them among almost all the parliament members in India, and towards my next step, I have started this web series to bring to the notice of the people each and every article of the Constitution, highlighting wherever it was misused, misunderstood, misapplied, as a result of which the country is suffering its results. By yesterday, we have completed our discussions up to Article 243 relating to local bodies, namely Gram Panchayats and municipalities. Today, let us discuss from Article 244 to 255. 244 and 44A relates to administration of scheduled tribal areas. There is not much to be discussed about that subject because there are not much controversies. So, let us go to discussions on Article 245 to 255 relating to center-state relations as far as law-making powers are concerned. Article 245 declares that the Union has power to make laws for the Union and the states have power to make laws for the states. 246 says that the Union has exclusive power to make laws on the items in list 1 of the 7th schedule. 7th schedule contains 3 lists. The list 1 is relating to matters on which the Union or the Parliament is entitled to make law. List 2 contains those matters on which states are entitled to make law exclusively. And list 3 is a concurrent list on which either the state or the center may make law. But when there is a law made by the Parliament on the same subject, that would override the state made law on the matters covered in list 3. We know it also determines the executive power of the President and Governors. Article 73 states that the executive power of the Union, as reposed in the President of India, shall extend to the whole country, including states and union territories, in matters which the Union is entitled to make law. And the executive power of the state is vested in the governor of that state, which extends to all matters on which the state legislatures are entitled to make law. The laws pertaining to union territories are also made by the Parliament. 246A relates to GST law. GST is divided into state GST and CGST, central GST and IGST. The provisions relating to CGST may be made by the Parliament and the states have power to make laws with regard to SGST, state GST. 247 declares that the Union has power to establish additional courts to cope up with additional work in the judiciary. Article 248 is about the residual powers of the Parliament to make laws. The Parliament can make law on issues which are not contained either in list 1, list 2 or list 3. And this power includes to levy any taxes. Article 249 clause 1 says that notwithstanding anything contained in the foregoing provisions, namely the allocation of items through list 1, list 2 and list 3. If the Council of States passes a resolution that the Parliament shall make laws on items included in state lists, namely list 2, then the Parliament shall be authorized to make laws even on the state subjects. Especially the Council of States, which we also call Rajya Sabha, is made up of the members elected by the assembly members of various states. As such, that is deemed to be representing the states proper. If that Council of States passes a resolution empowering the Parliament to make laws on the state subjects, then the Parliament shall be authorized to make laws on the state subjects also. However, Clause 2 provides a limitation. When the Council of States authorize the Parliament to make laws on state subjects, such authorization shall be limited to 1 year and extendable each time by a separate resolution. Article 249, Clause 3 says that the laws made by the Parliament based on the resolution of the Council of States relating to items on state list shall be in force for a maximum period of 6 months after the term of the resolution ended. Article 250 provides that the Parliament shall also be authorized to make law on state subjects during the time of emergency under Article 352. However, such laws shall cease to have any effect after the end of emergency period up to a maximum of 6 months. Article 251 says that, however, during the emergency or otherwise, state legislature shall have power to make laws on the matters contained in list 2. However, when they come in conflict with Parliament made laws, the Parliament made law would survive. To that effect, the state made laws will cease to have any effect. Article 252 says that 2 or more states, if they unitedly want that the laws pertaining to the state may be made by the Parliament, then the Parliament may make such laws for the states. And the states may adopt such laws afterwards if acceptable to the legislatures of the state. Article 253 says that the Parliament can make laws on the state subjects to fulfill any international agreements. However, if there is a conflict between the state made law and the center made law, the law made by the Parliament would survive. 255 says that where passing of any bill requires the recommendation of the governor or the president shall not be invalid only on the ground that such a recommendation was not made before the bill was passed. Once the bill is assented to by the president or the governor, as the case may be, its validity shall not be questioned on the ground that such recommendation of the governor or the president was not received beforehand. Article 256 states that the executive power of the state shall be exercised in such a manner that it would not militate against the executive power of the union. And the executive power of the union includes the power to give directions to the states. Article 257 says that executive power of the union extends to giving instructions to the states. And the state executive power shall be exercised without prejudice to the power of the union, and the union is empowered to give instructions to protect the railways and national highways by the states. Article 258 says that the president, with the consent of the state, may entrust any of the executive power of the union to the state governments, and the Parliament may by law entrust power to a state which otherwise has no power to make law on that subject, including imposition of taxes. The Parliament shall compensate for the cost incurred by the state as decided by an arbitrator appointed by the Chief Justice of India. Article 261 says that the laws shall be enforceable throughout the country. Any order passed by any civil court may be executed anywhere within India. In the next video, again, I come back with discussions on Article 262 and forward. 262 related to interstate water disputes. Thank you for watching my video. I request you to please subscribe, share and comment on my videos. I'll be glad to reply to your worthy comments. Thank you.